thank you, Nimer, for the kind introduction, and many thanks to the Center for Palestine Studies here at SOAS for endorsing my book and including it in your series. Shout out to my supervisor, Catriona Drew, who gave me a really hard time, but it was worth it, so thank you. Many thanks as well to all of you for coming. When I wrote the first draft of this book more than 15 years ago, as Nimer was mentioning, though he omitted the years, thanks for that. But I was a PhD student here at SOAS who attended many lectures in this very theater, so it's incredibly special for me to be here at this institution and for the launch of, this is the very first launch of my book. Before I delve into the various themes of the book, I'd like to pay tribute to all of our martyrs across the ancestral land of Palestine, to all of the orphans, the widows, the injured, and the displaced people in the occupied Palestinian territory. We failed to prevent the genocide in Gaza and have not been able to stop the ongoing Nakba, but we promise you we won't stop demanding accountability, and I hope that this lecture will help shed light on how we can demand accountability. Oops, what have I done? When I set out to research and write my doctoral thesis, it was in large part cathartic. I was searching for answers for myself as the daughter of Palestinian refugees and a Nakba survivor. I wanted to understand what happened during the Nakba from a legal perspective, not just the historical facts. Initially, I wanted to undertake a holistic research to examine all of the legal consequences of the Nakba, from the war crimes and crimes against humanity, such as rape, torture, massacres, and forced displacement, to the looting of arts and public libraries, to the harm caused by intergenerational trauma. But the subject was too broad and obviously very hard to find a legal angle to it. And the research was far too complex to distill into the required 100,000 words. So I chose to explore one of the consequences of the Nakba, which was the expropriation of property. So why the right to reparations? Now first, as Nimer mentioned, my book focuses on Palestinian refugees in 1948 and the right of their legal representatives to demand reparations from the State of Israel for the expropriation of their private property. I did not look at subsequent waves of displacement, such as the rights of refugees displaced in 1967, or the rights of internally displaced Palestinians within the State of Israel. But there are many books that I do recommend and reference in my own. And why did I choose the topic of reparations? And there are multiple reasons for that. For one, I wanted to revive and center the Palestinian refugee issue. Perhaps not until recently, the focus has always been on, the wall, especially when I was writing my PhD. It was right after the ICJ advisory opinion on the wall. So I was mostly focused on the wall, the settlements, the siege on Gaza, but not so much on refugees. And I felt that they were a little bit of a forgotten category of people, and I wanted to bring back that topic to the fora. But I also wanted to emphasize the role of international law in achieving a just resolution. I was obviously, I still had more shady roses at the time, and thought that international law had a lot more potential than I do right now. But there is still a potential for international law, and I wanted to dig into that and emphasize that, and also emphasize its role as a tool for advocacy and diplomacy. But more importantly, I also wanted to use it to demand accountability. I wanted to demonstrate how reparations can serve as a deterrent for states that resort to forcible displacement to create or reinforce ethnically homogeneous entities. And look at where we're at now without accountability for all these decades. This has enabled Israel and emboldened it to carry on with these forced mass displacement. I also wanted to help Palestinian refugees understand their rights so they can advocate for them better. And lastly, as also Nimer mentioned briefly in the intro, the right to reparation was understudied. Whenever we talked about Palestinian refugees, the focus is always return and compensation, but nobody really looked at the broader right of reparations from a legal perspective. So from an academic perspective, I felt there was that gap to be filled. And so I want to take you today on a journey in time and explore the beginning of the Jewish settlement in Palestine. While most people trace that beginning back to the partition plan, the Jewish settlement of Palestine began much earlier when the Jewish National Fund, which I'll refer to as JNF, was established in 1901 with the aim of buying and developing land in Palestine exclusively for Jews. But what were the land laws that existed at the time? And so let's start with the Ottoman period. Some of you may know the Ottoman rule in Palestine started in 1516 and lasted until 1917. In 1858, Ottomans compiled the Ottoman Land Code, which I will refer to as OLC, and introduced 5 categories of land. The sovereign retained legal interest in the last 3 of them. So I'll briefly talk about these categories of land just so you kind of understand how things were organized at the time. Waqf is still a category of land that exists to this day. It's land dedicated for pious use. It's not exclusively for, while exclusive to Islamic law, non-Muslim communities were also able to dedicate land to Waqf. Mulk comes from also the Arabic word, ownership. It's privately owned land. It's it can be used and disposed of freely and inherited, and there are no taxes to pay to the sovereign. But that was such land was very rare in Palestine and concentrated in the center of towns and villages. Miri, on the other hand, was the predominant type of land in Palestine. The sovereign retained interest in it, and while granting the right to possession or tasarruf in the land on the condition that it is kept cultivated. So for as long as this land was kept cultivated, the owners, like the individuals, still had ownership in it. The difference between mulk and miri is that the owners had to pay a tax to the sovereign. There were initially restrictions on sale and transfer and also inheritance, but with time and with the enactment of a legislation in 1913, which is the law of disposition, even these restrictions on the disposition and use of the land were subsequently removed. So miri became akin to privately owned property. Miwat and Metruke were 2 other types of land ownership. I'll talk a little bit on. So Metruke is mountains land or land in the vicinity of villages. Miwat, and Metruke is commonly owned land or land commonly owned by inhabitants of a village. So here you have a concept that is a little bit foreign to Western ownership laws, which is the concept of communal ownership of land. So in other words, if we look at without delving too much into the granular details, the majority of land in Palestine was owned whether by individuals or communities, and public land was essentially just restricted to lands which are subject to the control of the government and used in execution of its purpose, such as the erection of government houses, etc. Now, why is this an important point to make? And for 2 reasons. One is the expropriation of private property is prohibited under international humanitarian law. And 2, more importantly, assimilating native land to public land is one of the tactics used by colonial settlers to expropriate native property. And you can see the similar tactic in, I grew up in Canada. It's a similar tactic that was used in Canada with foreign settlers who came into Canada and essentially looked at the property as public land when in fact it was communally owned by the tribes who were living in, the indigenous tribes who were living in Canada at the time. And so this quote by Kedar is quite relevant. There are several ways in which settlers' legal systems hamper the attempt by natives and other alien populations to claim and protect land in their possession. Often, the settlers' legal systems altogether deny any recognition of native land rights, even when the native group has been in possession of the land since time immemorial. This denial is based partly on a cultural clash of paradigms in which the modern Western legal system does not recognize the ways locals organize their spatial relations to land as giving rise to property rights. Typically, settler states regard these native lands as public land, which can be disposed of by governments without the natives' approval or even knowledge. Similarly, Israeli law and British mandatory law did not recognize land possession by Arabs when this possession did not conform to the exigencies of formal Western law. As Shahade has demonstrated, this tactic continues to be used. Raja Shahade is a legal scholar, a Palestinian legal scholar, and founder of Al-Haq. So he's argued actually that this is a tactic that continues to be used to this day to expropriate privately owned property in the occupied West Bank, where Ottoman land laws unfortunately still apply. And so one can conclude that the vague and confusing categorization of land introduced by the Ottomans left the door open for the Israeli government to consider falsely the majority of lands in Palestine, including Miri land, Mewat, and Metruke, as state-owned in order to expropriate them from their rightful owners. So what were the other characteristics of Ottoman law and laws that clashed with Western law? And these were, so as we said, the vague and confusing categorization to begin with, but the other is also the land system, the individual, rights acquired over land relied heavily on possession and use of land instead of formal registration. Registration, however, as we all know, plays a pivotal role in Western legal systems of land ownership, and it's an essential proof of ownership. It was, however, rarely enforced by the Ottomans. According to land expert Sami Haddawi, owing to the failure of the Ottoman land registration machinery, the majority of the lands of Palestine were found on British occupation to be unregistered and under imperfect and obsolete registration. And when property was actually registered, the peasants didn't want to be, like the fallahin, didn't want to be paying or wanted to reduce their exposure to taxes. So they reduced sometimes the size of the property, or were tempted to register the land in the name of large landowners in order to reduce their exposure to taxes. And therefore, areas registered were a fraction of the true land area. In fact, according to Kenneth Stein, who's the author of The Land Question in Palestine, in 1925, 3/4 of all land in Palestine was held by unregistered title. In addition to the lack of registration and under-registration of property, the description of lands registered did not include any maps or cadastral surveys to identify easily the property. The land registry was in fact a registry of transactions between persons rather than a registry of title, making specific references to defined plots of land. So all of these factors combined, the vagueness in the categorization of land, the fact that the ownership relied on use and possession rather than formal registration, and the incomplete description of the land made the whole system basically vulnerable to exploitation and opened it to exploitation basically subsequently. So this brings us to the period of the British Mandate. And the British Mandate essentially did not abolish Ottoman land laws. Instead, they reformed the registration of land and introduced something called the Land Settlement of Title Ordinance in 1928. The land ordinance focused mainly on clarifying and settling ownership rights in the land. Rights recorded in the land registry would then be viewed as conclusive evidence of their existence and supersede all other rights or contradictory claims over land. The mandate, however, ended before all land in Palestine was accurately mapped out and registered. According to Haddawi, by the end of the mandate, some 25% of land in Palestine had been surveyed, mapped out, and registered. It's only 25%. The British administration eventually published a map in 1947 and submitted it to the Special Inquiry Committee of the UN, which eventually recommended the partition of Palestine into 2 independent states. This recommendation was subsequently endorsed by the UN General Assembly in Resolution 181. Now, it is interesting to point out that most of the land surveyed fell into the part proposed for the Jewish state, raising serious questions about the relationship between the settlement of title scheme and the UN's partition plan. As the British authorities were keen to ensure that Jewish settlers acquired a valid title to their land, they focused their settlement of title process on areas designated as settlement areas. These were mostly Jewish areas or areas subject to dispute between Jews and Arabs. Another thing that the British Mandate has done is dispatch several commissions of inquiry. I won't get into the details of all of them, but I suspect that you might have heard at least of one of them, which is the Peel Commission. How many of you have heard of the Peel Commission? Okay, so that's what I thought. Of course you did. And so the Peel Commission was the first official British document to suggest partition. So there were other commissions, by the way, that had not suggested partition. It wasn't until 1937 that the Peel Commission suggested partition of the territory of Palestine as a solution to the seemingly irreconcilable objectives of Jewish and Arab nationalism. However, if you remember also the history of Palestine between 36 and 39, this was what was it? Thank you. Okay, some people are studying before coming today. So yes, it was the Great Arab Revolt, which presumably might have been also considered the very, very first intifada of the Palestinians. And so no sooner had the report been published that Britain realized that this might be a bit of a controversial topic, and they began a step-by-step retreat from the Peel Commission's recommendations. In fact, a lesser-known recommendation or white paper was the MacDonald White Paper issued in May 1939, which empowered the High Commissioner to prohibit and regulate transfers of land to Jews. It also curbed Jewish immigration and envisaged the creation of an independent binational state of Palestine by 1949. What do you know? This wasn't a novel idea, after all. So the binational state in which the two in Palestine, Arabs and Jews, share authority in government in such a way that the essential interests of each are secured. With the promulgation of the 1939 MacDonald Paper, Britain dropped the idea of partition and re-emphasized its responsibility over the whole of Palestine. However, British ordinances did little, if anything, to restrict transfer of land ownership to Jews during the mandate period. Now, despite all of that, despite the fact that there were no restrictions on Jewish purchases of land until the very end and they were ineffective, despite all of that, maximum Jewish land holdings in Palestine on the day the State of Israel was established in 1948 stood at how much? Anyone?
3%?
7. That's close enough, but good. At 7%, at less than 7%. Actually, some say 5.6, and I think Sami Haddawi said 6.7. But overall, despite all of this, the facilitated process of land ownership and immigration, Jews owned less than 7% of the land and constituted less than 30% of the population. So whenever you look at the partition plan, if you have an image of it, remember these figures. Remember that 7% of the land was owned by the Jewish population at the time, constituted 30% of the population, and were given 52% of the land, including the most fertile areas and almost the entire coastline. Hence, that's why it was rejected, just so that we have the context of why the partition plan was rejected. So now the Nakba, I won't get into the historical facts of the Nakba. Presumably, you know what happened, and I've read Noor Masalha and Ilan Pape and so on. But essentially, the dispossession of Palestinians required 3 actions: the forcible displacement of Palestinians from their land, destroying villages and property to preclude return and restitution. We see these 2 methods being used, live streamed on our phones for the past 15 or 16 months in Gaza. But the third action was separating refugees from the legal title to the land through a variety of laws. And that's the one I'm going to delve a bit into. And so Israeli land legislation began getting enacted as soon as the State of Israel was created. The absentee property law was initially enacted in the form of an emergency regulation in 1948. These regulations had the effect of confiscating the property, both movable and immovable, of any physical or legal person falling under the legal definition of an absentee. And the definition potentially includes almost all Arabs, including Palestinian citizens, who were temporarily out of the territory of what later became the State of Israel, even if they were away for business or leisure at the time of the adoption of the Absentee Property Act. More disturbingly, this definition affects Palestinian citizens who did not cross over the borders into Arab territory and fled only a few miles away from their villages within areas under Jewish control. When the fight subsided, these individuals were also barred from returning to their homes and subsequently declared absentees. This generated the problem of internal displacement in Israel and created a fictional legal status of present absentees. These Palestinians were absent for the purposes of the law, yet very much present in the State of Israel. Pursuant to these regulations, the absentee property would vest into a custodian of absentee property. Now, this was a common method of handling enemy property law, so that's not the controversial part. And typically in other conflicts, the property would remain with the custodian for the duration of the war, and subsequently, once there was an armistice agreement, it would be released from under the custodianship. What happened was something that was different in the case of the Palestinians is that so initially the custodian could not permanently dispose of absentee property, and they could only lease it for a period not exceeding 5 years. These regulations were adopted, by the way, 9 days before the UN General Assembly passed Resolution 194, which we'll get into in a minute, which called for the return of refugees to their homes and compensation for the losses they incurred. The US, by the way, opposed these regulations and considered them prejudicial to the refugees' rights. But due to pressure from the JNF, the Jewish National Fund, to have title to the land rather than a long lease, they kept putting pressure until the Israeli government adopted the absentee property law of 1950, which allowed the custodian to sell and grant long leases of absentee property to a development authority, or the DA. The DA, in turn, sold it to the JNF and the State of Israel. The Development Authority Law of 1950 consolidated that. It allowed the Development Authority to sell to the state and the JNF, which benefited from a right of first purchase. And these restrictions essentially guaranteed that lands of Israel would remain exclusively under the control of the state and the JNF. In other words, beyond the reach of their original Palestinian owners. The Israel Basic Law of 1960 consolidated further that concentration of land within few entities, and it's named them Israel lands. Israel lands are comprised of lands owned by the State of Israel, the Development Authority, and the JNF. Ownership of such land cannot be transferred either by sale or by any other manner. So this reserved pool of land was administered by the newly created Israel Lands Administration. It is estimated that Israel lands currently form 92% of the total lands in Israel, of which 12% belong to the JNF. A more recent law called the Israel Land Reform Law in 2009 allowed the sale of and privatization of some of the lands, but the whole aim of that, again, is to frustrate any future possibility of returning the above-mentioned lands to their original Palestinian owners. So now that we've established how Palestinians were dispossessed of their land and property, what are the legal consequences? What are the grounds for the right to reparation? The breach of an international obligation or the commission of a wrongful act engages the responsibility of a state to provide reparations under the laws on state responsibility, as Nimir mentioned, is in the introduction. But due to the complexity of the principles of state responsibility in relation to historical facts, and a topic that Catriona and my other supervisor gave me a hard time with, called the intertemporal law. It's pretty dry, and I'm going to skip that part. And I'm going to focus instead on the other grounds for reparations, grounds that you might find more relatable, and you often hear about these resolutions. So the other grounds for the reparations are some of the most often cited resolutions related to Palestine. The one we're probably most familiar with is Resolution 181, which is the partition plan. So as you know, on May 14th, 1948, but actually, let me read to you what the partition plan says in relation to property in particular. It says, no expropriation of land owned by an Arab in the Jewish state or by a Jew in the Arab state shall be allowed except for public purposes. In all cases of expropriation, full compensation as fixed by the Supreme Court shall be paid previous to dispossession. On May 14th, 1948, the Jewish leaders grounded the declaration of the Jewish State of Israel on the strength, I'm quoting, on the strength of the resolution of the United Nations General Assembly Resolution 181, end of quote. So although UN General Assembly resolutions are generally not binding, the nascent state of Israel has accepted this resolution and relied on it when it declared its independence. A study prepared by the United Nations Committee on the Exercise of the Inalienable Rights of the Palestinian People concluded that, and I'm quoting, since of the two states envisaged in the partition plan, Israel was the only one to come into existence, it bore the obligation of discharging the responsibilities towards its minority population as prescribed by the partition resolution. End of quote. So as discussed from the onset, the State of Israel had a long-term plan to deprive Palestinians of their property and transform their land into Israel lands. It has therefore violated its obligations towards the Arab minority under Resolution 181 from the get-go. A few months later, the UN Security Council adopted Resolution 46, which called on all persons and organizations in Palestine, and especially upon the Arab Higher Committee and the Jewish Agency, to refrain, pending further consideration of the future government of Palestine by the General Assembly, from any political activity which might prejudice the rights, claims, or position of either community. This resolution was passed only a few weeks before the State of Israel was declared in May 1948. And at the time, the Haganah, which was the main paramilitary organization and later became the regular army of the State of Israel, had already set in motion a military plan which called for the destruction of villages and their encirclement, and I'm quoting, "In the event of resistance, the armed force must be wiped out and the population must be expelled outside the borders of the state." That plan was Plan Dalet, that you might have heard of, or Plan D. But perhaps the most often quoted resolution in relation to Palestinian refugee rights is UNGA Resolution 194. This resolution was based on the recommendations of the UN mediator to Palestine, Comte Folk Bernadotte, who was assassinated in September 48 by Israeli paramilitary Zionist group Lahi. And his last progress report to the UNGA, Comte Bernadotte condemned the pillaging and destruction of Palestinian property in the absence of military necessity. And he held the Israeli government liable to restitute private property to its Arab owners and to provide them with compensation. Acting on Bernadotte's report, the UNGA adopted Resolution 194, which established a lesser-known organization mandated to provide protection to Palestinian refugees called the UNCCP, the United Nations Conciliation Commission for Palestine, and requested it to assume the functions of the UN mediator on Palestine in view of reaching a final settlement on the Palestine question. More specifically, with regards to refugees, the UNCCP was instructed in paragraph 11 to provide the following. So I've highlighted here some of the words that I'm going to focus on, and everything that I'm going to say about these words is based on the drafting history of that resolution. And I wanted to delve into the drafting history of the resolution to demonstrate the intentions of the drafters at the time and how they approached the Palestinian refugee issue. And this also helps you see where the policymakers were in terms of their thought process and where we are today. When we look at the word refugees, by refugees, what was intended at the time, because this is like in the heat of the 1948 war, Nakba, it wasn't clear who was going to be the winning party. And so it meant all refugees, irrespective of race or nationality, provided that they had been displaced from their homes in Palestine. Therefore, paragraph 11.1, which is this one, applies both to Arabs and Jewish refugees who had been residing in Palestine and were displaced from their homes during the 48 war. It does not apply to Jewish refugees who fled from other Arab countries in 1948 or in subsequent years, nor does it apply to Arab Palestinians who lost their lands but not their houses. For example, a Palestinian residing in Gaza who owned land in the Negev and subsequently lost it when Israel declared its sovereignty over the Negev in 1948 would not be considered a refugee under 194. The other word is wishing. Wishing is that there was an element of choice. So according to the wording of Resolution 194, only those refugees wishing to return should do so. The debates at the General Assembly reveal that what was intended there is, and I'm quoting, to confer upon the refugees as individuals the right to exercise a free choice as to their future. This also highlights how the rights of refugees are individual rights rather than collective rights, unlike the right to self-determination. Therefore, each individual refugee has a choice as to his or her future and should not be forced into a settlement which would bargain away this individual right. Other words that I've highlighted in terms of the choice is return and compensation. And a lot of the time, people think that it's either or. So either you return or you get compensated. But that's actually not the position of the law and certainly not the position of the drafters of Resolution 194. In fact, the choice here is that refugees had between repatriation to their homes and compensation for damages suffered, or compensation for all the property left behind. So either they return and get compensated for the damages that they've suffered, or they get compensated for all the property left behind if they choose not to return. And again, the emphasis here is on the choice. And by implication, if those who return are entitled to compensation for the damages, then this would imply that there would be a restitution of property to begin with. Note also the use of the word homes. According to the UNCCP's records, and I'm quoting, "There is no doubt that in using this term, the General Assembly meant the home of each refugee, i.e. his house or lodging and not his homeland. This is indicated by the fact that 2 amendments using the term, the areas from which they have come, were rejected." Think of how normalized now it has become to suggest that Palestinian refugees from Akka, for example, should return to a Palestinian state in the West Bank and Gaza. But the intention is, and the right that individual refugees have, is to return to their actual home. Anything else would be a form of internal displacement. I've highlighted the words "live at peace." Now, these words gave rise to interpretations suggesting that Israel has a right to seek assurances from refugees that they wish to live in peace. But in fact, the opposite is true. If we look at the UNCCP records, what you can conclude, and here I'm quoting again, is that Israel has an obligation to ensure the peace of the returning refugees and protect them from any elements seeking to disturb that peace, end of quote, rather than a right to limit the rights of refugees to return. Therefore, the refugees have a right to live at peace with their neighbors rather than an obligation to provide assurances to Israel that they're able and willing to integrate peacefully. The words "permitted to do so," this is an injunction for primarily the state of Israel to allow them to return, but also the territories in which to which the refugees had fled, to allow them also the safe passage to return, and thirdly to the governments in whose territory they are, but through which they need to cross in order to get to Israel. So, for example, if they fled all the way to Iraq, Jordan should give them also access to get to Palestine. So this is permitted to do so, and despite the use of the word "should" here, when we say "should be permitted to do so," delegates who addressed the issue during the drafting debates at the General Assembly were consistent in either stating or assuming that Israel would be expected to repatriate. To dispel any ambiguity on this issue, subsequent General Assembly resolutions explicitly referred to a Palestinian return as a matter of right. At the earliest practicable date, it was also argued that since the General Assembly resolved that refugees should return at the earliest practicable date, their return cannot materialize until a formal regional peace agreement is reached. This was not, however, the intention of the drafters. During debates on the wording of the resolution, Guatemala had in fact submitted an amendment which would have required contending parties in Palestine to declare peace before refugees are permitted to return to their homes. This amendment was opposed by none other than the United Kingdom, who noted, and I'm quoting, "the fact that it might be many years before a formal peace was established in Palestine." And the United States delegate as well was not in favor of the amendment either. He stated in unequivocal terms that, and I'm quoting, "his delegation could not accept the proclamation of peace as a prerequisite for the return of refugees and hoped that the Assembly would not make this a condition. It was recognized that the bulk of the refugees could only return in peaceful circumstances. However, they need not wait for the proclamation of peace before beginning. These unfortunate people should not be made pawns in the negotiations for a final settlement," end of quote. Can you imagine that this was the position of the U.S. Delegate at the time? So you can see how much the policies have changed and the positions on the rights of refugees have changed over time. But what is the significance of 194? You might argue this is a General Assembly resolution. It's pretty old, and it's non-binding and whatnot. But almost 80 years after its adoption, this resolution is constantly readopted and reiterated and reaffirmed every year since 1948. The binding legal force of this resolution rests not on the resolution itself, but on the declared law. And Israel's binding obligations towards Palestinian refugees flowed from its specific undertaking when applying for membership in the UN to implement General Assembly Resolution 181 and to safeguard the rights of the Palestinian Arabs inside Israel, and Resolution 194. So, great, you might say. Now that we've established that there is a right to reparation, so what do we do with it? Who do we sue? How can we enforce it? And while in my book I've explored many I'm just mindful of the time. We're good. While in my book I've explored multiple venues for reparations, I want to briefly touch upon the pros and cons of litigation before domestic courts, as it seemed to have gained wide appeal lately in Gaza. So are domestic courts ever a suitable avenue for the resolution of mass claims for reparations? And here I wanted to respond to this question, I wanted to draw lessons from the 1990 Holocaust restitution movement in US courts, because it is perceived as, at least in the general public, as a successful precedent. But what really happened there? On October 3rd, 1996, the Vice House lawsuit, a class action lawsuit against Swiss banks filed in a New York federal court, marked the beginning of the Holocaust restitution movement in the US. 3 lawsuits later, the Swiss banks succumbed to the pressure and decided to come to the bargaining table in the summer of 1998. Faced with additional lawsuits in California and after several months of negotiation, the Swiss banks finally agreed to settle for $1.25 billion on August 13th, 1998, which at the time was the largest settlement of a human rights case in US history. Meanwhile, German corporations were also being dragged to US courts by plaintiffs demanding compensation for their slave labor during the Nazi era. After close to 60 lawsuits were filed against more than 20 different German and Austrian firms for their exploitation of slave labor during World War II, at the initiative of German Chancellor Gerhard Schröder, the German Economy Foundation Initiative, also known as Remembrance, Responsibility in the Future, was set up on 16 February 1999. In return for legal peace, in other words, a guarantee that all German companies, including foreign affiliates and parent companies, will be protected against lawsuits relating to the Nazi era, the Foundation Initiative member companies assumed so-called moral responsibility on behalf of the German industry. No admission of legal responsibility was ever made by the Foundation's members, in part because many of these member companies did not even exist at the time of the war, and because an admission of this kind would have granted ample justification for legal action against these corporations. Soon thereafter, the Austrian government and corporations followed suit and established the Austrian Fund for Reconciliation, Peace and Cooperation in November 2000. The fund was modeled on the German Foundation, and similarly, no acknowledgement of legal responsibility was ever issued by either the Austrian government or the corporations. So what was the secret of the seemingly successful reparations campaign, and why weren't other reparations claims met with the same success, whether we're talking about slavery claims or indigenous rights claims or claims brought by the internment of Japanese Americans? And there are several reasons for that success. One of them was the unique feature of the American justice system. In the American justice system, there's the ability of foreign citizens to file lawsuits for human rights abuses committed in foreign land. There's also the recognition of jurisdiction over foreign defendants that do business in the United States, or even over claims that occurred abroad. The class action lawsuits are quite actually prevalent in the States. Lawyers also have the ability to take on cases on a contingency basis. So this is when they're not paid upfront, but they get a percentage of the award. There's also a legal culture in which lawyers are willing to take on high risks with a low probability of success in order to test the limits of the law. Fixed and affordable court fees, and the existence of an independent judiciary, at least for now. God knows where things are heading. But also there's the practicalities of an enforcement. There were lots of obviously German and Swiss and Austrian assets in the US to enforce a judgment against, and that made it easy to put that kind of pressure. And a lesser known fact is actually none of the cases went to trial. At least at the beginning of the Swiss banks. In August 1998, when the Swiss banks agreed to a settlement, almost 2 years after the first lawsuits were filed against them, none of them had proceeded to trial. For the first cases, the defense lawyers filed motions to dismiss the suit on procedural grounds, and plaintiffs obviously argued that the suits should be allowed to proceed to trial. But on August 1st, 1997, after hearing the oral arguments of the Swiss banks' defendants' motion to dismiss or stay, instead of ruling on the motions, Judge Corman stalled the decisions. Hence, none of these cases ever made it to trial. And there were no ruling on the merits. Arguably, had the cases even been allowed to proceed to trial, they would have failed on procedural and jurisdictional grounds. The inherent weaknesses of these claims began to surface by the time lawsuits were filed against German companies. On September 13, 1999, the Holocaust restitution movement suffered its first legal defeat when 5 slave labor lawsuits were dismissed by federal judges sitting in New Jersey who examined the cases on the merits instead of stalling the proceedings. Other factors that obviously contributed were European guilt, the support of the US government, a massive PR campaign for those who are old enough to remember. But also another element which is very relevant and interesting to point out is regulatory pressure. Swiss banks faced the threat of financial sanctions in several states. These threats were successful because they were aimed against private enterprises, not government. They were for the single limited purpose of affecting the outcome of a lawsuit, and they were endorsed by high-ranked officials in various states, and if used would have damaged the bank's capacity to conduct business in the US. So you can imagine all of these banks and corporations faced with these massive lawsuits and with the courts stalling the process and the proceedings. They wanted to rush to have an out-of-court settlement, and essentially that's what happened. But since sanctions were used against Swiss banks, the U.S. Supreme Court has rendered this decision in 2000 severely limiting the power of states and local officials to issue them. In terms of Palestine, if we think of what is happening currently for Palestine, there are 35 states that have passed bills and executive orders designed to discourage boycotts of Israel, which would make the imposition of sanctions on companies doing business with Israel even more challenging. So in summary, the success of the Holocaust reparations were owed to a set of unique circumstances and can be hardly considered a legal precedence. In fact, if anything, as law professor Roy Brooks stated in his comprehensive study of Black reparations, the Holocaust litigation precedent demonstrates, I'm quoting, an unmistakable judicial indisposition towards lawsuits that seek redress for past injustices. In the absence of special legislation or settlement, these lawsuits have been dismissed before the judge has had an opportunity to consider the merits of the claims at trial. Every slave redress lawsuit that has been decided thus far has met with a similar fate. These precedents essentially suggest that when cases pertaining to events which occurred in a distant past and at times on foreign soil are filed before domestic courts, they are likely to be dismissed on procedural grounds. So does this mean we shouldn't consider domestic courts at all? I don't think so. I think there are limitations and advantages to pursuing claims in domestic courts. So let's look at the limitations. The individual claims might be precluded in peace settlements. This is not the case yet for Palestinians, but this was, for example, the case for the slave labor lawsuits against German corporations, which were dismissed by U.S. federal courts on the ground that the various treaties signed between Germany and the Allied powers precluded individual private litigation. We know that in the Nakba talks of 2001 between Palestinian and Israeli negotiators, there was the issue of the end of claims was in fact discussed, and it was suggested that the implementation of the agreement would constitute a complete and final implementation of Resolution 194 and therefore an end to all claims. So this is something that we need to be aware of. The other impediment would be sovereign immunity. The doctrine of sovereign immunity is the primary ground for the dismissal of claims against the state before the domestic courts of another. There are some exceptional cases, but it's obviously very hard because usually it's limited to commercial transactions rather than reversing historical injustices. So while Israel can use the doctrine, so bear in mind, while Israel can use the doctrine of sovereign immunity to shield itself from the jurisdiction of another state, this immunity is only procedural. It does not exempt Israel from its obligations under international law to provide reparations to Palestinian refugees. And also, we need to distinguish between cases against the state and cases against corporations. Nothing would preclude bringing cases against corporations because the doctrine of sovereign immunity wouldn't apply. And that was the case. That was why the cases against the Swiss banks and the German corporations were relatively successful from that perspective. Another limitation is the lack of standing. It would be hard for Palestinian refugees who were not American citizens at the time of the commission of the crime, a crime committed on foreign soil without any nexus to the states, to establish some sort of standing. Another impediment would be statute of limitations. The statute of limitations was one of the main procedural obstacles to the success of slave redress litigation in the U.S. The more chronologically remote the events are, the more difficult, the more likely these claims will be time barred. Additionally, when the injustice is far removed in history, it may be harder to identify a class of plaintiffs which would be entitled to recover from any settlement. And this is particularly the case when the direct victims of the injustice have passed away or when the harm done was personal or physical rather than material. But this is not an insurmountable obstacle. In fact, one way to surmount these procedural barriers is to enact legislation which would overrule statutes of limitations or other procedural impediments and explicitly grant courts jurisdiction over claims pertaining to a very specific set of facts and a well-defined class of plaintiffs. These sorts of legislative developments are typically preceded by a significant historical or political event or political pressure generated by the victims themselves and their supporters. This actually happened after the fall of the Berlin Wall. There are a lot of Eastern European countries that adopted legislation to allow for claims for lost property to be brought to the courts. Another major, actually, impediment, specifically in the case of the Palestinians, because you've got millions of claims, is capacity. Local claims or domestic courts are going to have a very hard time managing such a heavy workload or caseload. And another, which is even more problematic, is lack of uniformity. If cases are filed in different jurisdictions, there is a great risk that the awards will not be uniform, even when cases bear similar facts. This could lead to tension and disappointment among the refugee communities who would view these inconsistent results as yet another form of injustice. Cost is another one, and this also is likely to fuel some resentment for those who are, in fact, the majority of the refugee population who may not be able to afford bringing cases before local courts. And another one that concerns me even today is just raising expectations. Lawsuits can raise expectations among victims while their chances of success are very limited. Legal action can also drag on for years, and time is against the aging survivors of the Nakba. The dismissal of a lawsuit could also be misinterpreted in the court of public opinion as a case weak on merits. As such, there is a risk that an unsuccessful lawsuit could diminish public support for Palestinian refugee rights. And obviously, lawyers charge a lot, and they can be abusive. Sorry, yes?
4 minutes.
4 minutes, thanks, okay. Yeah, I am almost done. So potentially finding but the potential is finding lawsuits, even if unsuccessful, can be a strategy in itself. It can be a mean to apply pressure to force an out of court settlements, as we saw with Germany and Swiss lawsuits. But also it's a platform to challenge narratives, and we see how effective this has been in the past 15 months. There are additional themes that I explore in my thesis, which we can probably tackle in the Q&A, such as the other avenues for mass claims reparations, the forms of reparations, and also how the refugee issue was addressed in the so-called peace process. But to conclude, I'll leave you with this. When I initially wrote this book as a doctoral thesis, I thought the Nakba was a moment in history with a beginning and an end. Over time, it became clear to me and to all of us that the Nakba is ongoing, that the Nakba is a structure, a process, a framework, rather than a one-time physical act of expulsion and dispossession. As Palestinian scholar Rabia Ighbari wrote, I quote, "What is distinctive about the Nakba is that it has extended through the turn of the 21st century and evolved into a sophisticated system of domination that has fragmented and reorganized Palestinians into different legal categories, with each category subject to a distinctive type of violence. Fragmentation thus became the legal technology underlying the ongoing Nakba. The Nakba has encompassed both apartheid and genocidal violence in a way that makes it fulfill these legal definitions at various points in time while still evading their particular historical frames," end of quote. So while the bombs may have stopped raining down the skies of Gaza, there are still homes being destroyed and people displaced in Jenin, Tubaz, Masafir Yatta, and Tul Karim. While Palestinians are returning to the north of the Gaza Strip, Palestinian refugees in Lebanon, Syria, Jordan, and even those within the occupied Palestinian territory continue to yearn to return to their homes in Haifa, Safad, Lid, or Yafa. It is therefore crucial to view the events unfolding before our eyes today as part of a continuum that started with the colonization of Palestine over 100 years ago. The weaknesses in the Ottoman land code continue to be exploited by Israel today to dispossess Palestinians in the OPT, and the process and plans of mass expulsion, destruction, and expropriation of the Nakba continue to be deployed by Israel in Gaza, in Jenin, and even within the state of Israel against Palestinian citizens of that state. This is the ongoing Nakba, and it is impossible to conceive of any permanent resolution of the struggle for liberation that wouldn't address the root cause of it, the theft of a nation. In the meantime, the question of Palestinian refugees and their struggle for justice will persist, and Israel's transfer policies will continue to force Palestinians out of their homeland, with Israel's full knowledge that it would not be called upon to provide reparations to those it has wronged. It is therefore incumbent on us not to allow it to evade accountability and to deploy the law and leverage it in our quest for justice and freedom. We owe it to the survivors of the Nakba, past and present. Instead of ceasefire now or end the occupation, our goal and chance must be the Nakba must end. Labud lil Nakba an tantahi. Thank you.